Tennessee Court Talk is a podcast presented by the Tennessee Supreme Court, Administrative Office of the Courts. The aim of the podcast is to improve the administration of justice in state courts through education and understanding. The target audience varies and is announced in the beginning of each episode. Welcome to Tennessee Court Talk.
I'm your host, Barbara Peck. Today we are talking about juvenile courts in Tennessee, and this podcast is intended for all audiences. Our first guest is Judge Vicki Snyder. She is a juvenile court judge in Henry County. Our second guest is Judge Dan Michael. He's a juvenile court judge in Shelby County. Our third guest is Judge Tim Irwin, a juvenile court judge in Knox County. And our final guest is Judge Christy Little. She is a juvenile judge in Madison County. Welcome to you all.
Thank you.
Thanks. Thank you.
So all 95 counties in Tennessee have a juvenile court, as juvenile courts are part of our county court system. And so overall, Judge Michael, what is the mission of juvenile courts in Tennessee?
It's according to what part of the juvenile court you're talking about, of course. In juvenile justice, it's rehabilitation. In cases of dependency and neglect, it's what's in the best interest of the child, trying to help families reunite, get families back together, or get children in a permanent placement. So it varies from docket to docket on what our actual goals are. I don't know if anybody disagrees with that, but I think
a common misconception is people think that we are here to do the same thing as what happens to children in adult court. We are bound by the statute that says we rehabilitate children. If the only way they would be punished is if they're transferred from our courts. So people get frustrated sometimes with the juvenile court system because they feel like we're not doing enough. But we rehabilitate, and the adult system punishes, and that's very important. And in Madison County, I think the biggest thing that I worry about is that we keep our families and children safe, but we also keep our community safe, and that balancing act is very, very difficult sometimes, especially in those sensitive cases.
So let's talk a little bit about delinquency. And so what kind of rehabilitation efforts do you have available to you, Judge Snyder?
Well, I'm in a rural county, so my resources are limited compared to suburban and urban areas. I'm lucky I have Carey Counseling Center, which is available to us through the Juvenile Justice Reform Act. There's a grant that makes Carey Counseling available to us. They're in court with us every time we have court, whether it's child welfare court or juvenile justice court. And they are available to meet the needs of the children that need a rehabilitation. Also, the Department of Children's Services is available to us to meet those needs as well. I do not have grants. I don't really use grants for juvenile justice cases because I am a rural county. It's difficult to hire people under that grant in that area, and someone to move to Henry County or take a job under a grant program through juvenile justice, and then that grant dissipate or go away. That person perhaps has moved to Henry County, bought a house there, and if the grant ends for whatever purpose, let's say it's through a federal grant, that grant is no longer available through the state. That person then is in Henry County where there aren't a lot of jobs, and then that person is there with a house and perhaps no job. So I use a lot of creative programs that we use in Henry County that are at no cost, such as what's called an options program where kids, actually it's an out-of-detention weekend program that my part-time staff oversees and supervises. So rehabilitation, community service, treatment for A&D issues, and those kinds of things. I have to be creative because I'm rural and don't have a lot of resources.
So Judge Irwin, tell me a little bit about what options you have for defendants who are delinquent or unruly.
Well, first of all, let me say that's way less than 10% of what I do are the delinquent and unruly children, but we have a plethora of options. We have a program called Home Base, a very intensive form of probation run by the Helen Ross McNabb folks. We have a show cap designation, which makes an officer come by your house at night, check, see if you're in for your curfew. Those two things help us keep from placing kids in juvenile justice commitments. We've also got a fully licensed PhD clinical social worker on staff that can meet with our children in detention, and she has 6 master's level students, so we can address mental health needs quickly for kids that have to wait in detention to have their cases heard because of safety concerns. And we also have a big presence with the department. I have 46 employees there in a county of 400,000, so we have adequate resources. What we don't have sometimes is placement beds as quickly as we'd like them if we do have to commit a child. I have 707 children in DCS custody, and only 26 of those children are in juvenile justice custody. So 680 on the dependence and neglect side and 26 on the juvenile justice side. So it's not a big part of what I do, but we have adequate resources right now to handle and help keep kids from going down the custody road when possible, when safety allows.
So let's talk a little bit about that, because I think that the misconception is that juvenile court really is handling juvenile justice issues, like kids are being sent to juvie. I think that's what the public or a lot of people would think that you do. But as you're all shaking your head yes to me, that's really a small part of what you're actually doing. So tell us a little bit about your docket, a typical docket for you, Judge Michael.
Well, in Shelby County, we have a resurgence of violent juvenile crime. It's up about 65% over last year, which has caused my docket to crowd up with transfer hearings. My docket is solely set to hear transfer cases. Our DA files about 250 notices a year, which causes me to give her a hearing on those cases. So I spend my day managing those 250 filings, getting reports, getting psychological evaluations done, getting everything ready to go for a hearing. It's unusual. You know, Shelby County is the poorest urban county in the state. We have the highest number of single-family households. We have the highest number of households on government assistance. So poverty, one of those correlating factors to crime, is huge. About 40% of our children in Shelby County live in poverty. And when you have those types of infrastructure problems, lack of shopping centers and grocery stores in the inner city, and gangs, you have a crime problem. So my daily docket is looking at young adults coming in who are committing very serious offenses. We get about 6,000 delinquency referrals a year in Shelby County. That's still not the majority of our business. The majority of our business in Shelby County is child support work. It's over half our docket. And then we'll get another 3,000 to 4,000 abused and neglected children coming through our courts every year.
So tell us a little bit about the differences between unruly and delinquent.
Well, an unruly child or a status offender is an act that can only be committed by a child. The 5 or 6 of us could run away today and nobody's going to arrest us, or smoke a cigarette or drink alcohol or disobey our parents. Children aren't allowed to do that, and that's an unruly act or a status offender. A delinquent act is an act which would be a crime if you were an adult, and that language is used purposefully. We don't want to label children criminals. If you read the statute, it still has that old language in it. We want to remove the taint of criminality from the child so that they can grow up and be productive citizens without that delinquent act chasing them through adulthood.
And so I'm going to stay with you for a minute here. So tell us a little bit about how you decide and what factors you look at when you're deciding whether to remove a child from juvenile court to adult court.
It's pretty straightforward. There are 3 primary laws that you have to look at in the transfer statute. One, probable cause that the child committed the act they're charged with. So I have to find it's reasonable to believe that the child committed the act. The second one is what I call committability. Is that child committable to an institution for the developmentally disabled or mentally ill? And if they are, it stops the proceedings. If they fail to prove probable cause, the proceedings stop. Last but not least, what the TCA says, Tennessee Code Annotated, community requires legal restraint and discipline. This is where the legislature hands off that crystal ball, I guess you'd say, to the judge. We have to look at that child's history, how they've responded in the past to treatment efforts if they've been in court. What have we done to try to help them? How many systems have they been through? And you consider all those factors in making a decision on whether you believe the child can be rehabilitated. If you get to the point where a child has been in the system a long time, has graduated through all of our local service providers on into the Department of Children's Services, and is still committing violent acts, then you get to a point where you say, I'm sorry, but I don't have anything for you. You have to go to the adult system. It's a very, very difficult decision to make because you're essentially giving up on that child's potential.
And Tim, I would say the two most difficult cases as a juvenile judge that we have to determine, and I think all of us will agree, that I lose sleep over at night, even though all the factors are met and you feel the transfer is the only option. The two most are transferring a child to adult court. Those are the days you wake up in dread and fear. And the second is terminating a parent's rights to be a parent. And it's almost an awesome response. I mean, that we even have the ability to say you are no longer a parent to a child in a case. It's very, very difficult to do that. Judge Irwin was very, very successful in getting some new surrender forms that have made it so much easier for a parent who feels they can't adequately, for many reasons, parent a child. And if a parent comes in and decides to surrender on a day when I would have to make that determination whether or not to terminate, it's a win for everyone. And now with the new legislation that allows parents to contract with the adoptive families, it also is another piece to that puzzle that makes me feel at night that job well done for my staff, and that everybody's done their job. But those are the two things that, as a judge, I think all of us would agree are the most difficult: transfers and terminations.
I agree with that, because sometimes when a parent surrenders their rights, and we go through the process which we're dictated to go through, I will say to the parent, because it's generally a parent I've dealt with in the dependency and neglect court, usually in an earlier case. When I'm satisfied that that parent is doing so under no duress or coercion, this is something they wish to do because they want their child to have a better life. And when we are finished and the crying has ceased, I will say to that parent, this is the greatest act of love you will ever demonstrate for this child. And then the conversation is, I recognize that, and I want my child to have the life that I never had. Because usually that parent is a product of the environment that their child has been living in, which is usually, domestic violence, drug addiction, poverty, homelessness, and they want better for their child. And so the fact that Judge Irwin championed the cause of having a surrender form that was less cumbersome, and we have that now, makes that process so much less difficult and less painful for that parent that wants to surrender.
And as an adoptive parent, and I'm an adoptive parent, I can honestly say to them, what you're doing is the most It's the most difficult decision. If they don't cry and they're not upset, it's heartbreaking to me, because it is such a wonderful gift for a family to be able to have a child they can love, but it's also the most unselfish thing you can do to say, I just know that in my heart of hearts, that this is the best thing. And it's not just the women, it's also the fathers as well, who come in and say, I just simply cannot do this. And those are the days when you go home and you kind of have a little zip in your step once you finally get past, like the tears, as Judge Snyder said, once you get past that, to know that you want to know the outcome of that and the Christmas cards that you get. That's why it's easier to get up some days and do the jobs that we do.
So, Judge Irwin, this form that you helped create.
The magic form.
The magic form. Tell us a little bit about what you were seeing and what was the motivation there.
Well, I was dealing with a case that was the surrender was actually taken down in Panama City. And I got the surrender, and it was 1 page. And our surrender at the time was about, 60 pages maybe. Mm-hmm. And so we took a look at what we could do to shorten it, and we tried all kinds of different ways to shorten it through committee with the Department of Children's Services. Finally, it just took a simple statute change, put the new form in there. And now this legislature, they're changing it to make it even shorter. But I think that's a good thing. People understand that they're giving up their rights. That's the main point. And they understand that it's forever. And they understand they got 3 days to change their mind. And that's a really good thing. A lot of times when I go to work every day and I come home at night, I've made a child's life better by my direct actions. And that's what keeps you going. When you have days where you have to where you have to bind a child over to the grand jury to be tried as an adult, those are hard. And, I feel for Dan having to do so many of them. I think the more vigilant you are on the dependence and neglect side, the less cases you'll have to have on the transfer side. If you raise a child correctly, if he has someone in his life or she has someone in her life that loves them, if they're not had a bunch of trauma and adverse childhood experiences, and they grow up with someone caring about them and going to school, they're not likely to end up in front of us with the state asking for a transfer. If they're raised like an animal, then they'll respond like an animal.
You tell the child they're bad, they'll prove you right every time.
Absolutely.
And they learn by example.
If you're vigilant and you have the ability to take children out of bad home situations early in their life, they turn around. There was this huge, huge scare when the opiate crisis hit about how are these children that are born drug exposed, what kind of effect is it going to have on them when they're older children and teenagers? And so far, honestly, I have to say that effect's been much less than we thought it was going to be. I see kids going to foster homes very quickly, and they're becoming part of those homes and living good lives. And I haven't seen too many emotionally disturbed children because of what happened to them in the womb, and I'm so thankful for that. We were really scared when the opiate crisis hit what was going to happen, and I see one once in a while, but not very often.
Don't you think that the Safe Baby Court concept has also made that better?
I think that
Absolutely.
It's been a phenomenal effort to keep children with their mothers. The hardest thing we have to do is tear a child away from its parents. That's very difficult. Whether you're terminating, whether you're taking them away the first time, you take away a baby from a mom that's just had that child. That's rough on you. That's rough on you. It's rough on them. It's hard on the child. To sever that bond between a newborn and its mother is.
If they don't bond initially, it's very, very difficult. And we have a program in Madison County, actually it's in Gibson County and Humboldt, run by Aspel, called A Mother's Love, where we take the women when they're pregnant and have opioid issues and try to get them off those drugs. And then after the baby's born, they stay with their child in that facility for 6 months minimum, most of the time longer. And we have found great success in that program, Pathways, and all these other agencies come in and work closely with the parents, with Aspel, and it has just been amazing. I think, Tim, Judge Irwin, you've had some mothers with us, and Judge Snyder as well. We just hadn't had any. Memphis has Baby Love and some other programs, but keeping those children and mothers together when they're first born is a bond that if you don't get on the front end, you don't get on. It's hard. It's an attachment disorder issue, and so I think that was something we were concerned about, is what are we going to do to keep that together. With that and Safe Baby Court that Senator Hale was able to legislate, and I think everybody in here, with the exception of Shelby, has a safe baby court now, but the goal is to have every county in the state to have that program. That we could talk the whole time as far as Barbara about that program, but we continue to proceed with the concept that prevention before detention, getting the children when they're young, keeps them out of the court system when they're older, because the statistics tell us that overwhelmingly, and y'all may know the exact number, I would say 90+% of the children that are delinquent were dependent neglected. Now, whether that was identified or not remains to be seen, but our goal is to keep them from getting to that juvenile justice track and keep them safe and happy and healthy before they start committing offenses that change their lives forever.
One of the things that's coming down the pike that I think is going to really help us with these cases, these welfare cases, is Family First Prevention Act was passed by Congress, allowing the states to draw down what we call 4D money from Title 40 of Social Security Act and use it in different ways. And as a judge, when I'm told that mother goes to the med and has a baby that has cocaine in the bloodstream, well, today the department's going to go in and remove that child. After Families First comes on board, they will be able to place that mother in a residential provider facility with the child and help her get past her addiction. And what I like about the act and the training I've gotten on the act so far is that it acknowledges that mother will probably fail at some point in time during that treatment. Almost all addicts do, but that's not going to be held against them. And the really exciting thing is it's 15 months of treatment. That's a long time, not 30 days, not 90 days, 15 months. With that, I think what we're going to see are fewer and fewer families coming before us where we have to remove the children if it works the way it's supposed to. Now, Tennessee took a waiver, so I think it's 2022 before they launch it, but they are doing training around the state on Families First. So I'm looking forward to the application of that system in Tennessee.
So tell me a little bit about, Judge Snyder, tell me a little bit about the dependency neglect cases that you see in Henry County.
Almost exclusively, they are, the genesis of the DNN cases are parent drug abuse or drug dependency. Very often there are multiple children involved, with the department removing, usually when law enforcement officers go into a home on a search warrant or after investigating something, and then law enforcement calling the department and the department then going into the home and removing a child or more children. Involves generally more than one father. Which involves the appointment of a guardian ad litem, attorneys for, and most all parents are indigent, which involves the appointment of counsel for mother, or the guardian ad litem, father or fathers. First and foremost, addressing the specific needs of the child or the children, whether they need to be tested for drug exposure, their specific medical needs. If they're older children, they generally have not had dental care. They haven't seen a physician, a pediatrician in some time. They may have abuse issues. They need to see a pediatrician immediately. And making sure they're safe, they're in a safe environment, generally with a kinship placement if there is one available where they'll be safe, because children need to be with someone that's not a stranger to them. It's so scary to just imagine these children are in the home. They may not see it as a dangerous situation. They love their parents, even though we see it as a bad situation, quote. But the police come in, it's scary. They're removed by people that are strangers to them. Then they're placed in a strange home. It is frightening. It's traumatic.
Every child, if they're old enough to talk, will tell you during the process that they just want to go home, no matter how bad home is.
That's right.
What's happened to them, they'll all tell you they want to go home.
I don't think I've ever had a child not want to go home.
So if there's kinship placement, an aunt, an uncle, a grandparent, where they can be safe, that is where we like to see them go. And then just providing the services with the return to parent, if it's appropriate, if the Department of Children's Services develops that plan, everyone's on board. If they can go home and it's a safe environment, reunification. If not, kinship placement. Down the road, if termination is appropriate for children, you have to follow that plan. It's not cookie cutter, as I said, different for every case, right. Different for every child. And we have to be in tune with that as judges, have to be attentive, have to hold the feet of the department to the fire, the attorneys, and ourselves. We are accountable as well as judges. There's a lot of work that goes into every case by all parties involved.
And if I can just say, the other piece of that puzzle is that a lot of the placements are non-custodial, and we're fortunate in Madison County to have CASA.
We do too.
And that's another piece of that puzzle, because if there's a relative in Nevada, then we can contact CASA in Nevada and get them to do a home study that would be a whole lot. We can expedite what Department of Children's Services would have to do, and we're able to place children. So CASA has been a wonderful benefit that we've had for years, that allows us to be able to also get into the home, see what, to be the voice of the child, which, as we've said, is to return home. But we want them to make certain. I think my two greatest fears are that I return a child too soon when a parent's not ready, and then that's even more devastating to have to remove, or that I don't return them soon enough, and it's difficult then for that bonding to occur, or things are already so difficult or different at that point in time. So CASA is also another piece of that dependency and neglect issue when you have to remove children. And in Madison County, we're seeing many more parents with the mental, or maybe they're just we're becoming more aware of the mental health issues. And 9 times out of 10, a parent who has a drug issue had a mental health issue, and they self-medicate. And we work closely with our mental health provider, Pathways. We have Quinco and other providers that are there. But mental health has been coming to the forefront lately, with more people not getting the services they need and not being able to parent because of that. And it's a fix, because certainly there's medication and there are things we can do, but that's also another piece of that dependency and neglect puzzle that we see, besides the drug issues. As Judge Snyder said, that's probably is the number one reason why most children are taken. We have physical abuse that does occur, but for the most part, it leans toward the use of drugs or the lack of mental health treatment.
So, Judge Irwin, when you're making the decision, when there's a family in front of you and you've sort of made the decision that the child can't stay in the home, what factors are you looking for when you're trying to decide where to place them?
Number one, safety. None of us want a dead baby or a dead child. So safety, it's not safe for the child to stay in the home of an active meth addict, oftentimes. And I say meth because that's 90% of what I see is meth, cocaine. I don't see many pills anymore.
Right.
And I had a tremendous pill-using population, but the medical folks have done a good job of cleaning up their practices. I don't see it. My people can't get pills anymore. They use meth and they use cocaine, and it's been my determination and that of my magistrates that they're not safe options while they're active users. So safety is the first determination. And we do look at what the child wants when they get to be a certain age. When they're 12, they can testify, and we listen to the children and try to put them at ease. I'm a big, scary guy, so the first thing I do in my court is hand children a teddy bear and let them hold it and squeeze it. Not all teddy bears, stuffed animals, everything from Barney to unicorns but it seems to work really well putting the kids at ease. But the first thing that I look at is going to be safety, and that's always going to be the case. The second thing I'm going to look at is the best interest of this child and where I can get this child where they'll grow and flourish and have a successful life. And that can be a whole lot, the considerations can be a whole lot different with a 6-day-old and a 17-year-old. And you have to look at, 17-year-old, you have to look at things like, how can I possibly get this child with a high school diploma or in a vocation, or get them in a place where they can succeed and want to succeed. You're in a more of a rehabilitation stage there, where with a baby you're wanting to get them in a place where they can get all this care on time growing up, so you won't be that 17-year-old with 3 high school credits and in a bunch of trouble.
We also have, if I can just say a pitch, we have Navi, who is our new security dog, who comes to court every time we have any removals. And I know you have
habit dogs is what we have. Yeah, they come in too.
And Navi has been probably the greatest addition we've had in a long time. No offense to all my wonderful Amy Jones and my director of juvenile court services staff, but everybody wants to see Navi. They don't want to see me, and they don't want to see people. They want to just get down on the floor and talk to Navi and deal with the dog listens. It's kind of like my dog when I go home. Sometimes my animals are the only ones that are glad to see me. So Navi brings that different element. Children relate to that. So that's something that all courts, I think, in the state should look into, because it has been a really blessed opportunity that we've had, and to see how that affects children as well. As Judge Irwin said, especially the children that are not the newborns, but any child that is available has the ability to rub a dog or have a stuffed animal, feels like they have something of their very own or something special that's not judging them in any way whatsoever.
About 10 years ago, I sat on a panel at Freed-Hardeman, which addressed the issue of aging out of foster care. Being 18, never been adopted, and there were 6 kids on the stage. And when they finished speaking, I asked them, as a judge, tell me what I need to know about you. Tell me the main thing that I need to know about you and what I can do as a judge to help the kids that come before me. And they said, nobody ever heard us. Nobody ever heard me. And so I left there and drove back from Henderson to Paris. And I was so overwhelmed with emotion. And I started immediately, especially kids that were old enough to understand. And I said, I want you to understand that with the dependency and neglect kids, that you're in state custody, or you're in foster care, not because of anything that you did. You did nothing wrong. You're here because of parent behavior. And I want you to understand, I'm always here to listen to you. You have a voice. You are the most important person in this room. And I began to see a change in these children when they would come to court. They stood taller and they had a command of the courtroom. And we started using therapy dogs about 8 years ago. And we had one, Tanner was a golden retriever. He died of cancer, and we were all devastated. And now we have 2. And the children come in, and and you can hear the tail of the dog hit the courtroom floor, and it's like bam, bam, bam. And they come in, and they immediately go to the dog. And we have a ratification of the permanency plan. And the children will go over and pet the dog, and then they get a sucker, and then they leave the courtroom. Because when we talk about then the court report, I don't want the little ears to hear some things that we're talking about. So to alleviate their fear of being in this scary courtroom, I'm up on a bench, they're down there. Sometimes I get off the bench and come around and kneel down and talk to them, because they're so tiny sometimes. And I think about my 5 grandchildren, when I'm talking to them, I kneel down and get at eye level, because they live in a world of big people, and they're little people. And then when my kids that come in are 16 and 17, as Judge Irwin talked about, and they are getting ready to be at the age of aging out, and you think about these kids at Freed-Hardeman and on that panel talked about, when I turned 18, my foster parents said, you still live here. this will be your home forever. You no matter what you do, you come back here and this is your home. Some had their suitcase put on the front door step, at the front door, adios. So at Thanksgiving, they were in a McDonald's and that was their Thanksgiving. Some lived in their car. I was heartbroken by that concept and that thought. So when we have that, the transition of that 17-year-old learning about permanency and how you can know how to get a credit card and fill out an application for an apartment or do those things that parents, that we did for our children.
Right.
They don't have anybody doing that for them. So we're not only dealing with the abused and neglected little ones, we're dealing with those 17-year-olds that are getting ready to turn 18 and don't belong to anyone. And everybody needs to be somebody's someone. These are children that need us.
Yeah, I'd like to stress a point I think Tim made earlier. I've seen maybe a half a dozen kids over the years, but I rarely see a child on my transfer docket whose background is horrendous. I mean, I have read files on children who are 15, 16, 17 who have done something really, really bad. And I've wondered to myself how that child survived that life. I rarely see a child turn 16 or 17, pick up a gun and go rob somebody. These are children who are abused, neglected to the point that the trauma in their life drives their life. You see fighting at school, you see fighting at home. A good friend of mine says it this way, we have an amygdala which controls the fight or flight in our bodies. And if you're in the woods and a bear walks up on you, you're either going to fight or you're going to flee. Hopefully you're going to be faster than the bear. What do you do when the bear is at home every day, all day, with you? And these children are coming up in situations, and that's what I see on my transfer docket. Now, it doesn't forgive their behavior, but it tells me why they're there. That's why this DNN, or this abuse welfare side, is so critical to what we do. If we can get those children safe in a home that's going to love them and give them the direction they need, I'll never see them. I mean, it's that close to what I'm dealing with on my end. And people forget that.
Interesting. I think someone made that point yesterday at one of the sessions, that there's such a fine line between the dependency and neglect cases and the delinquent cases. Sometimes they're just so mixed.
Oh, you can have a delinquent child that's also dependent and neglected. We run into that all the time.
Yeah,
Constantly.
absolutely.
Yeah.
So let's talk a little bit about, you mentioned a little bit, Judge Snyder, about who's in the courtroom in a juvenile proceeding. And I think one of the misconceptions we have is the Administrative Office of the Courts, we manage the indigent fund for when somebody can't afford an attorney, then they're appointed an attorney if the public defender can't represent them. And it's about a $43 million fund that the Administrative Office of the Courts administers. So I think there's a lot of misconception that is all going to capital cases and these people who have done these horrendous crimes. But the reality is 43% of that money is going into juvenile court. And so tell us a little bit about who gets a lawyer in juvenile court, and what is the role of the guardian ad litem, because that's something that's sort of fairly unique to juvenile court. It happens a little bit on other courts, but definitely in juvenile court.
In Madison County, everybody gets a lawyer. In a dependency and neglect case, where the child gets a guardian ad litem, the parent's mother, father, as long as they're indigent, which I'd say 98% of the families are indigent. CASA, we don't go forward. Obviously, in a termination of parental rights case, everybody will, but in Madison County, our goal is for every child. You get a sibling group, and that's where I get frustrated sometimes. You get a sibling group of 6 children that maybe have different fathers, that you have older children who have different interests than babies, and sadly, we may have one guardian ad litem and CASA. The goal for our CASA board is for every child to have a CASA representative, and usually I will take if it's a smaller group, I'll at least point two guardian ad litems, and we're blessed to be able to do that in our county and have attorneys that are willing to do that. They don't get paid enough, even though they are getting paid not nearly what they should be for the time they spend. But the children have differing needs. Now, also, if a child says, I want to go home, and it's just absolutely impossible because there's still a meth issue, we still have meth in the home, then sometimes we have to appoint attorney ad litems in some cases. But we always make certain that the children and the parents' rights are protected, because these cases, especially if it's a termination, are going up on appeal, and rightly so. We should, that's a decision that needs to be looked at. We're all human. Certainly, those things need to be tested to make certain if in fact there is a termination of parental rights. So everyone should, in those cases, have an attorney. And also in the delinquency cases, sometimes we may assess an amount less than what, an amount for the parents to pay if the child, every child has to have an attorney. They have the same rights. So in a delinquency case, it's just as important, because every time they commit an offense, that could be used against them later in a transfer hearing to show their past treatment efforts and their past delinquent history. So lawyers play such an important role in our courts that we don't give them the credit they deserve, and certainly the monetary amount, but we appreciate the AOC's efforts in making certain that we do have attorneys readily available. And our public defender does not have the manpower to come to our court, so all of ours, all the attorneys that come to court are being paid through the AOC unless they're the families are able to hire counsel.
I do appoint the public defender in juvenile court. If there's I make parents fill out affidavits in delinquency cases, and if the public defender if they qualify, I appoint the public defender. Now, if there's a brutal issue and there are co-defendants, then I appoint private counsel. We do have a day that the public defender comes. There's always that misconception in private custody cases where the petitioner always generally has an attorney, and then the respondent will come in and say, I want an attorney. Well, if there is dependency and neglect alleged in the petition and the respondent fills out an affidavit and they qualify, I will appoint counsel. But if there's no allegation of dependency and neglect and it's strictly just a custody issue, parental fitness, there's no ground for me. There's absolutely no ground for me to appoint counsel. And it is a difficult thing for me, because I recognize very often, because I live in a county of 33,000, which sounds big, but it's not. And sometimes I'll know just by recognizing the person, sometimes having been in criminal court, the respondent is not able to hire a counsel. And I'll explain to them, I don't have the ability to appoint counsel for you.
And sadly, Vicki, what do? We're also told that the AOC can't pay for a guardian ad litem if it's not a DNN. So you also have that child out there without the ability.
If the bottom line is, I just can do what I can do. So what I do have is I do have mediation available, and I have a local rule that if it's a non-dependency and neglect case, there's no dependency and neglect alleged, the first thing is I order mediation. Right. And mediation is resolving almost all my custody cases, because when they sit down with a mediator, it generally resolves everything, shy maybe occasionally of an issue or two, which I can resolve in a short hearing. So that's resolving most all of them.
And where do you get the payment for the mediators? That comes up a lot in our court.
It's just being paid. I mean, they're resolving it and they're paying it. So.
And do you ever have the parent that has the appointed, that has the retained counsel pay for a guardian ad litem? Because that's come up
most of mine are resolving through mediation. So I've not had. Occasionally, you'll have that contested case that's like something from a made-for-TV movie.
Yes.
That they're forum shopped. you found they've been to other counties and other courts, and everybody has those kinds of cases. And there's a guardian ad litem needed, and I've appointed a guardian ad litem, and I've ordered the cost split between the parties, because that's what's best for the child.
Sometimes they'll say, well, they've paid, and so, and there's so many cases where you need a guardian ad litem, because CASA also, their counsel will not allow unless it's dependency and neglect. And then the other piece of that, we see a lot of grandparents and aunts and uncles that get involved, and then the AOC will not pay for their representation, which I understand that, but if they're unable to hire and the grandparent is the person that's had the custody, that's also another piece of the puzzle where they have to go out and hire. But, that's also a mediation issue, hopefully, that can be worked out.
I think it's critical because I was on the Indigent Representation Task Force that met for, 18 months, that it's very critical that we get, as judges, we have the affidavits filled out by the litigants, that we assess the administrative fee, the partial indigent attorney fee when it's appropriate. Right. And that's not a cookie cutter issue either. It depends on the litigant themselves.
So let's talk a little bit about things that are different in juvenile court than in circuit court or chancery court or general sessions court. So how is privacy handled differently in juvenile court versus other courts?
Confidentiality. Welfare cases are closed court hearings, and they need to be. The family needs to be protected from the allegations that are made in public. The children don't need to be targeted by the allegations that are made. So those proceedings are closed to the public. And there is actually a criminal statute if a party to the proceeding releases the information to the public. They can be charged. It may be a misdemeanor, I think 11 months, 29 days.
It's a Class A misdemeanor.
Yeah, Class A misdemeanor. So the state's very serious about those proceedings. Juvenile proceedings are different, and it's kind of an odd mix of openness and confidentiality. Technically, juvenile delinquency proceedings are open to the public. But if the child is under 14, the only parties that can access the record are parties with an interest, the lawyers, the litigants, the defendant himself. Nobody else can get it. You can sit in court and listen, but you can't get the record. And then the second part of the statute, if you're over 14 and you've committed a certain level of felonies, those records are public. So it's a mishmash of confidentiality.
Child support's public record.
Child support's public record. That's right. Technically, custody visitation is too. So, yeah.
And how many times have you told a lawyer, we don't have a jury here? That's the other thing is a misconception, is that we don't have a jury, and sometimes lawyers will, and they have the right to certainly make a record for their appeal, but every now and then I'll have to remind them, this is I'm your trier of fact here, and there's not a jury, especially those that are usually retained that are used to doing that. But there would not be a jury in juvenile court proceedings. That doesn't mean when it goes up on appeal that they wouldn't. That eventually they might have some opportunity, but as it stands with our courts, we do not have that. People seem to think it's kind of like what you see on TV, and it's not like that. We don't, and it's not glamorous. It is life. Hits you right in the face.
Not many Perry Mason moments.
No, not really.
Or Matlock.
Yeah, so there are the Tennessee Rules of Juvenile Procedure, which are available for free on the website on TN Courts. But which rules do you see judges or lawyers tripping up on the most? That they've come in, they've been represented, and you're just like, juvenile court doesn't work the same as civil procedure laws or criminal procedure laws. Is there a couple we can point to sort of make sure you read the rules of juvenile procedure?
I have lawyers that practice primarily in circuit court that come down and get really hung up on a lot of formal discovery,
yes,
which I'm not too interested in. I'll play the discovery rules, which most of our juvenile court discovery rules just refer you back to the rules of civil procedure. Right. I mean, I'm perfectly capable of playing the game, but I'm not interested. I've got to move a lot faster. I don't have the luxury of hearing a 6-week divorce trial in juvenile court, I want to find out if there's dependence and neglect. If not, move on. I want to go through Judge Ash's 15 factors of best interest in a custody case and move on. And I don't want a whole lot else. I don't have time to figure out how much dad's going to be on mom or mom's going to be on dad. I have my child support magistrates handle that, and that's a big part of what we do too. I have 3 magistrates that work every day on unmarried parents' child support. There's 1 magistrate in Knox County that does the married folks' child support. That gives you a state of family life. Our little nuclear family, our Jetsons type family, is not the norm anymore. We have a large presence in our county from the Boys and Girls Club, and 83% of the families they serve are non-traditional families. 83%. And that's probably, in our courts, I can't imagine too often we see both parents. It's just doesn't happen
rare.
that often.
Yeah.
Correct.
A lot of times I don't see any parents.
A lot of times it's grandparents.
Yes.
And it's rough. That's a rough thing to ask a grandparent to do.
Yeah.
So just to clarify too, so we talked a little bit about juvenile court decisions being appealed. Where are they appealed to?
That's the quagmire. And what do you do when a lawyer comes in and has their notice of appeal and it's going to the wrong court, and the clerk comes and goes, this is the wrong place. That's what we're looking at. No. It's but termination of parental rights goes up to the Court of Appeals, and I think that's obvious.
As does unmarried parent visitation, as does child support.
But dependency and neglect, basically custody or dependency and neglect cases through DCS, or even if there's a finding of severe abuse, they have, if we make that finding, they can appeal that decision. Those go to circuit court. Why? Who determines that? It's difficult. And if you're going to be an attorney practicing in juvenile court, if you're not up on the rules, and they are so different from any other court, you have to really know what you're doing when you walk in the door, because they always say we speak our own language. Everything has a CFTM, TCM, everything has an initial, and we speak in a different language, and we also have a whole lot of different rules, and if you don't know those things when you're coming in, it's not a quick learn, because it's taken us a long time sitting here to get to the point where we're able to work through those issues. And I think experience is the one thing you cannot substitute. So attorneys just need to look at those rules before they start appealing and going to the wrong courts.
It's not really that hard. Title 36 goes to the Court of Appeals, straight from juvenile court.
Right.
A magistrate can't hear a case and it go to the Court of Appeals. It requires intervention by the elected judge. So that's Title 36. Title 37, if you have magistrates, if you're a bigger county, we could go magistrate to judge to a circuit court level to the Court of Appeals. And that's the breakdown in the statute. And I think that at least one of those steps in Title 37 is unnecessary. I don't think I should be rehearing a case where a magistrate with 30 years of experience who's also a lawyer, I don't think I should have to rehear it before it goes to circuit court. That's getting 3 bites of the apple before you have an appeal. I'd like to see that change. I don't know that.
And one of the problems we have with that law, abuse and neglect and delinquency cases going to circuit, when they go up on appeal and the opinion comes back, we don't get the opinion, the circuit court does. So we're not getting direction from the appellate court on our child support welfare cases and our delinquency cases. And that's my frustration. I would like to get more guidance on certain issues. For instance, in a transfer hearing is not appealable. You can only appeal a transfer hearing by preserving the constitutionality after conviction. So you have to go to criminal court, be convicted as an adult, and then take your appeal.
Rarely happens.
Rarely happens.
And I think the one thing that if we leave with anything other than people maybe learning and being enlightened by juvenile court is this, that as juvenile court judges, the decisions, and this is from the words of Judge Walter Baker Harris, the decisions that we make every day could affect a child's life forever. And we can't have a bad day because that child could come back later and explain to you what that decision that you made did to them. So I take that very seriously. I think that's one of the most important things a juvenile court judge needs to know is that we have to go in every day fresh and ready because every child deserves a trier of fact and someone who'll listen, because if we don't do the right thing, we're not dealing with we're dealing with children and children's lives, and I think that's where a juvenile court is the most important court in the court system, and that's spoken from the heart.
Thanks to everyone for joining us for this episode of Tennessee Court Talk.
Thank you.
Thank you.